Okay, I think we'll start, and hopefully we'll see Susan and Mariana joining us very soon. And okay, so I'll start us off. So hi everyone, welcome. On behalf of the Comparative Administrative Law Listserv, the University of Arizona College of Law, the Review of European Administrative Law blog, or the Real Law blog, we're very happy to welcome you to this webinar. And it's a special webinar because we're celebrating the publication of a new foundational source in the field of comparative administrative law. I'm showing you that new source. This is the third edition of Edward Elgar's Comparative Administrative Law Research Handbook that has the suggestive and thought-provoking, I think, subtitle, New Voices, New Perspectives, and that was edited by a really impressive team of editors, Peter Linseth, Mariana Mota-Prado, Blake Emerson, Farah Ahmed, and Megan Pfeiffer. We have a really rich plan for you today, so I just want to sketch it briefly so you'll know what you're kind of like, what you're here for. And then we'll move to start us off, and I will make introductions that are somewhat more formal about the different participants. So we're going to open, hopefully. Susan will join us very soon, but our plan was to start with opening remarks by Professor Susan Rose Ackerman, who together with Peter Linseth actually initiated the Research Handbook project back in 2010. Then the plan is to hear an overview of the handbook and its vision from three of the handbook's co-editors who could join us today, Mariana Prado, Blake Emerson, and Megan Pfeiffer. Following that, our plan is to hear presentations about two of the handbook's really impressive chapters from two of their co-authors, Tavini Nanayakara and Noah Rosenblum. Next is a pretty special treat, I think. We will hear from two distinguished commentators who will comment on the kind of generally on the handbook or on particular chapters, Emily Bremer and Francesca Bignami. And finally, we will make sure to leave time, or that's our plan, for some intra-panel discussion amongst us and audience Q&A. So the plan is for me to introduce the speakers as we go, and I will also monitor the chat throughout the webinar. So if anybody wants to ask questions, please leave it to the end. But if you have something that is really burning, I will also keep tabs on the chat. I suspect we don't have Susan, right? I don't see Susan. So what do you think? Megan, Blake, could you start us off? Does that make sense?
Sure, I'd be
Let
happy
me
to.
introduce you. Perfect. Okay. So, just, the niceties and stuff that you won't say. So this is why they pay me the big bucks. So I'll say all the niceties myself. So let me just introduce two of the co-editors of the handbook. So Blake is a professor of law and a professor of political science at UCLA Law School who writes in administrative law, constitutional law, and political theory. And Blake, I should mention, obviously, was a co-auditor on the second edition of the handbook, together with Susan and Peter, and continues to the third. And Megan Pfeiffer is a doctoral candidate at the Faculty of Law of the University of Toronto, with interest in public law and legal, political, and moral philosophy. So the stage is yours. I will shut up.
Great. Thanks so much, Oren. Hopefully you can all hear me well. So I just want to thank you so much for organizing this event. It's a real pleasure to see this third edition of Comparative Administrative Law in print. I'll just say, Jay, a few words just to situate this third edition in the longer trajectory of comparative administrative law. I mean, comparative administrative law goes back as a field, at least to Frank Goodnow's book of that title at the very beginning of the 20th century, in a study of French, English, and American administrative law. But under Susan Rose Ackerman and Peter's leadership, as well as others, there was a revival of interest in the subject in the early years of the 21st century. And I came on the team for the second edition of Comparative Administrative Law when I was doing my doctoral work with a different piece of public domain modernist art on the cover. And Megan carries on that fine tradition in the third edition of doing truly excellent work as a graduate student in editing the chapters and formulating the volume and contributing to the introduction. One thing I'll just say about the overall trajectory of the field over this period, if you look across the three volumes, I'd say is a shift from a more cosmopolitan and global perspective to one that's more pluralistic and differentiated. I think the outlook, and this is true of many different fields, I think, but if you look at the outlook at the outset of the series of the century, I think the first volume came out around 2010. The outlook was one of a world of a high level of global coordination across regimes, including national, supranational, and international orders. The EU was highly consolidated. Global administrative law was a major interest in areas such as federal aviation and trade regulation. And there was a sense that there was kind of a universal set of principles that were superimposed across a number of different legal orders. And across the three volumes, I think that global universal cosmopolitan perspective, if it hasn't, I wouldn't say it's collapsed, but I think it's been complicated by recognition of tensions and diversity and different historical trajectories and influences across different regimes. Which is not to say that comparison is no longer useful. It actually becomes more useful in that context. And one of our hopes for this volume was to shine a light on some of those major axes of difference, including the colonial background of administrative systems in many countries, and the ways that sometimes creates affinities across nations that are quite different, and also raises really difficult normative questions. So I would shine a light on a few really interesting chapters here. Gio Quino's chapter on the vernacularization of administrative law in African nations that have to date often relied on a common law model that was more or less transplanted from Britain, as well as Andrew Edgar's chapter on semi-parliamentary regimes in Australia and in the UK, and the way that the upper house, the upper chamber of the legislature, has a role in reviewing rulemaking. And of course, I should mention our host, Oren Tamir's excellent essay on the major questions doctrine in comparative perspective, and the way in which there's been a raft of criticism, myself included, of the major questions doctrine in the American context. And Oren shows masterfully the way that other regimes, namely Israel and Germany in particular, have doctrines that are quite similar, and which really invites interesting normative and empirical reflection over whether this is a doctrine that's appropriate in the American context. So that's just to mention a couple of the really excellent chapters in the volume. I know we'll hear more about Noah Rosenblum's later in this talk. I'm so glad to have the opportunity to discuss this volume now that it's finally out. And I'll pass it over to Megan for some further thoughts.
Hi, folks. Can you hear me okay? So I've just had to remove locations because actually there's a massive demolition going on next door. And I thought that we wouldn't be troubled by the percussive sounds, but it sounds like there's a massive jackhammer going.
Are
So
you in,
I
are you
hope
in the
you
White House?
no, I'm not, but I might as well be at this point. If anyone is having difficulty hearing me because of the sounds, can you please just let me know? Thanks so much. Okay, so thanks for that awesome bit of context, Blake, on the sort of trajectory of the project and the content of the volume. I want to use a few minutes just to say a bit more about the process behind this particular volume itself. In particular, I want to focus on the workshop we hosted at the University of Toronto, the group of scholars we brought together, and what I think is one of the most exciting outcomes of the volume, which is the community that is now taking shape around comparative administrative law. So this volume grew out of a workshop that we hosted at the University of Toronto all the way back in October 2024. It's kind of frightening to think of how long ago that was. But the workshop model reflected the editor's aim to do more than publish a set of chapters. Instead, the aim, I think, was to continue a conversation amongst the community that had been started by the earlier editions. And conversations, of course, take their shape from who's in the room, whose voices are heard, and how the participants engage with one another. The central goal for this third edition was to bring in what we've called new voices and new perspectives into the conversation. That meant an emphasis on identifying emerging scholars working across a wide range of jurisdictions, many of whom were already engaged in really fantastic comparative work, but may not have had sustained opportunities yet to exchange ideas with one another. Tavini Naniakara, who we'll have the pleasure of hearing from in a few moments, is a really great example of the kind of emerging scholar the editors wanted to bring on board for this project and fully integrate into the conversation. The sessions at the workshop were designed to prioritize exchange, so papers were circulated in advance and the emphasis was on discussion. During that discussion, contributors had the chance to receive detailed feedback, not just from the editors, but also from one another. The workshop was a space where scholars were engaging each other as peers, testing ideas, challenging assumptions, and finding unexpected points of connection. I think it was really the gold standard of exchange in that way, and I had a lot of fun there. During this exchange, you could see common themes begin to crystallize across very different projects. But you could also see something less tangible and perhaps more important, which was the formation of a shared intellectual community around this subject matter. I should note also that I'm another one of the lucky early career scholars who was brought on board for this third edition, as Blake mentioned. And that allows me to speak from a personal experience when I say that the expansion of this community through the workshop was one of the most valuable outcomes of the project. It created space for the kind of conversations that continue after the formal sessions end. And many of us have stayed in touch, continued to engage with each other's work, and in some cases have begun to formally collaborate, which I think is a huge success. In that sense, the workshop was not just a step towards producing this volume. It was also the continuation of something ongoing. And that to me is one of the most exciting aspects of this project, one that's deeply connected to the work of the Yale Comparative Administrative Law listserv. And thanks again to you folks for hosting this great book launch. Comparative administrative law is still a relatively young and evolving field. It doesn't have a single dominant method or a settled set of questions. And that can be a challenge, but it's also an opportunity, especially for junior scholars. It creates a space for new approaches, for new perspectives, and for new forms of collaboration. What we saw in Toronto was a glimpse of what that future might look like. A field that's more globally connected, more attentive to diversity of administrative law experiences. And that's really exciting to me. So while this book is, of course, something we're very proud of, I think it's also worth seeing it as a part of a larger progressive project. If the first two editions helped to revive comparative administrative law as a field, this third edition is in many ways about broadening and sustaining it, about ensuring that the next generation of scholars is drawn into the conversation and given the space to push it in new directions. If the contributions gathered in this volume are of any indication, that conversation is, I think, in very good hands. Thanks a lot.
Perfect. So Mariana, welcome. I'm going to introduce you, I guess, and give you the stage for a couple minutes to give us your perspective on the handbook. So we're joined by Mariana Monteperdo. She's one of the co-editors of the handbook, and she's a professor at the Jackman Faculty of Law at the University of Toronto, Canada, where she holds the William C. Graham Chair in International Law and Development. Mariana, the stage is yours.
Thank you so much, Aaron, and my most profound apologies for being late. I hope I will not repeat anything that Blake has said. I'm glad I was here to catch Megan's remarks. As Aaron mentioned, I was one of the editors of this third edition, but my involvement with the project started since the first edition. So I have been contributing as an author first to the first edition and the second edition. I brought chapters on the Brazilian regulatory agencies for both of these editions, and I was absolutely honored to be promoted, I think that's the word, to an editor. It was, I think, for all the reasons that Megan articulated, was a delight to work on this project. The intellectual engagement, the exchanges, the learning was very rich. But one point that I want to emphasize, and again, I hope I'm not repeating anything that Blake has already mentioned, was the Global South dimension. We really made an effort to include a series of Global South jurisdictions that are not often featured in a lot of the comparative law publications that we can find out there. More specifically, we see efforts to do comparison around the world, but for reasons that I think are related to resources and how the networks are structured. So I'm not putting blame or fault on anybody here, but North America and Europe tend to dominate these conversations. So we did a very active and intentional effort. We engaged in a very active and intentional effort to bring Global South voices and bringing jurisdictions that are often not featured in existing debates. So I think that was a fascinating exercise in the sense of hearing about problems and issues that I think are not often portrayed in the literature. And the second thing that I want to emphasize is how interdisciplinarity also came into this volume, I think in ways that were a little bit present in the first two, but they really became prominent in this volume. So there is a few chapters in which you have what we call law and society scholars, analyzing what happens on the ground, the street level bureaucrat, what are they doing, and how does that dynamic compare with the law in the books, right? So this literature on law in the books and law in action came full force in the volume. And I think that was also a very interesting dynamic because people are doing that from a comparative standpoint. And I think it's like comparison on steroids because you're doing the comparison of law in the books and law in action plus comparison of two different jurisdictions, which is what we asked the authors to do. And it was fascinating to see the authors rise to the occasion, bring all this interdisciplinary analysis to enrich the way we look at comparative law and the way we do comparative law. So I think these are the 2 points that I would like to raise. Oren, thank you again for organizing this. And again, my apologies for being late.
Great. Thank you to the three of you for kind of, giving us the backdrop of the project. I think Susan Rose Ackerman is still not with us. I know she's trying. So if that's okay, I think we'll move to chapter presentations. So Tavini, I think you're going to go first. So I'm just going to say briefly, Tavini Nanayakara, she's one of the co-authors of one of the most interesting chapters in the handbook. She's a lecturer at the Department of Private and Comparative Law of the University of Colombo and currently reading for her PhD at the University of New South Wales in Sydney, which also explains why it's 2:30 a.m. For you. So I'll keep the time, Tabini, and we're looking forward to hearing from you.
Thank you, Aaron. I'm very happy to be here to speak on the chapter that Dinesh and I wrote on the development and diffusion of the public trust doctrine in South Asia, even at 2:30 in the morning. As the introduction by the editors to this volume state, and I think Megan, Mariana, and Blake mentioned as well now, this volume is dedicated to providing a stage for, if I may quote from the introduction, new voices and new perspectives, while also expanding the geographical coverage and broadening the scope and diversity of issues and jurisdictions with a special eye to the Global South, close quotes. And I think our chapter falls squarely within this description. So scholarship on the comparative administrative law field in South Asia is sparse. We've encountered one other notable piece by Melissa Crouch on prerogative writs as constitutional transfer, which is historical in it that it tracks a global genealogy of writs as a colonial common law transfer leading to its constitutionalization. Her article is an explicit comparative administrative law endeavor, especially including an intra-South Asian comparison. the hope in writing this chapter was to add to this nascent scholarship. To briefly introduce this chapter, as the title suggests, we trace the diffusion of the public trust doctrine in South Asia and explicitly ask the question of whether it's used to further environmental constitutionalism or something beyond. So the public trust doctrine is, as we know, a doctrine leading to a judicial remedy, characteristically used by the public to hold the state accountable for failure to maintain resources in trust held for the people. This is a public law concept which is developed from the Roman law and English common law. And in South Asia, we recognize 6 jurisdictions in which the public trust doctrine has been invoked, largely under the jurisdiction. And these are India, Sri Lanka, Bangladesh, Nepal, Pakistan, and Bhutan. Given the large number of jurisdictions being mapped out for the first time, this chapter only attempts to make a very modest, comparative, doctrinal, and descriptive mapping of how the public trust doctrine has been invoked in South Asian jurisdictions. I think I'll make 3 main points with regards to the chapter. The methodology we adopted in the chapter, comparative insights with regards to the public trust doctrine, and the potential for future research. Point 1, this chapter is both doctrinal and comparative. A word on these methodologies a little further as we've used them in the chapter. So Varuhas, in his article, Mapping Doctrinal Methods, recognizes 4 methods of doing doctrinal work, which are description, derivation, systematization, and interpretivism. And according to Varuhas, as the methods progress, they rise in sophistication, and the higher level of doctrinal method is said to include the lower level. For instance, derivation would include description, systematization would include description and derivation, and interpretivism would include all 3. In our chapter, Dinesh and I have engaged in what we believe is a descriptive mapping of the invocation of the public trust doctrine, or the PTD, in South Asia in administrative law. And Varuhas claims that it's rare today to find academic work that is purely descriptive, and how, and I'm quoting, one may question whether a piece that's purely or mostly descriptive could qualify as scholarship at all. Despite these claims, we hope the chapter would qualify as an important scholarly intervention for several reasons. As a first of its kind exploration of how the PTD has been invoked in South Asia, the project's first step demanded a near comprehensive descriptive mapping of how the legal systems of South Asia have treated the doctrine. And given the sheer breadth of jurisdictions covered, to make any additional value judgments or theoretical conceptualizations, we felt would spread the contours of the work too thin. We also believe that descriptive work done well has the potential to be part of more analytical work in future. In this work, therefore, we purposefully refrained from engaging in explanatory reasoning or prescriptive statements on the PTD and solely focused on how it's treated in the status quo. We utilize the comparative methodology to the extent of engaging in horizontal, inductive description of the manner in which the PTD has been invoked in South Asian countries. We also acknowledge, although we don't have the space to address it, that the political and economic context in these countries undermines the impact of the judicial decisions. So like Mariana mentioned, there is law in practice, but this is pretty much law in the books that we've discussed. Point 2, some of the interesting findings pertaining to the PTD in South Asia that we discovered are 6-fold. First, we found the common law to be the basis for invoking the doctrine. Courts of India have invoked the doctrine since the 1990s to protect the environment. We therefore refer to India as a pioneer in the use of the doctrine. Minor reliance on the doctrine has been made by Bangladesh, Nepal, and Pakistan to protect the environment. Dominant use of the doctrine has been made by the judiciary of Sri Lanka by invoking it to protect the environment, as well as to curb the abuse of public power, which is also held in trust for the public by constitutional actors. This approach differs slightly from Bangladesh and Bhutan, where the doctrine is said to be recognized explicitly in the constitution. The second finding is that the PTD is pretty much a constitutional doctrine. While the doctrine is largely invoked under the writ jurisdiction, it also combines fundamental rights and constitutional obligations more broadly. As I mentioned, Bhutan and Bangladesh explicitly recognize the doctrine in their constitutions, but it also has been invoked in India, Sri Lanka, Pakistan, and Nepal under various fundamental rights like life and liberty, sovereignty of the people, right to a clean environment, and directive principles of state policy. Bhutan's constitution, interestingly, even provides for a quantitative threshold of 60% forest cover that is to be maintained at all times in operationalizing the PTD. The third finding is that the PTD has been used to further environmental constitutionalism. While all countries have resorted to this, Sri Lanka takes a unique approach to such protection through a concept of shared stewardship. The fourth finding is how the PTD has been buttressed by both international law and foreign law. The courts of South Asia have in general invoked the Stockholm Declaration in 1972, US case law, and notably the work of one American scholar, Joseph Sachs. Importantly, most jurisdictions refer to Indian case law, and Bangladesh also relies on Canadian and Pakistani case law in invoking the doctrine. While India appears to be a regional leader in the diffusion of the doctrine, this seems to be unidirectional in the sense that India doesn't seem to refer to its other South Asian neighbors. The fifth finding is how the PTD has been factored in for judicial review of competing interests in economic growth. However, we also found that there have been exceptions to this, where economic exploitation has been justified under the doctrine, as long as the exploitation of the resource held in trust is for the benefit of the public itself, and where economic development has been interpreted in line with the doctrine in Bangladesh, such as protecting natural resources held in trust for the public for the very purpose of attracting tourists. Bhutan provides evidence of a country that appears to be married to its quantitative constitutional obligation of maintaining 60% forest cover even at the cost of economic growth. The last finding is how the PTD has been used as a right against arbitrary use of public power in Sri Lanka. This has not been done in other countries in South Asia. This has been done specifically in two key cases, one to invalidate the premature dissolution of parliament, and the other to hold several key officials responsible for the economic crisis of 2022, where the doctrine has been used as a ground of review to check arbitrary use of public power by constitutional actors. Despite these developments, Sri Lanka has not been referred to by its South Asian neighbors or beyond. An exception was when a current sitting judge of the Supreme Court, sitting in the Court of Appeal in Seychelles, invoked the doctrine in Sri Lankan case law in the protection of the environment. To my last point, further research potential. In this work, we, as I said, purposefully refrain from providing any conclusive statements about the PTD beyond the divergent ways in which it has been invoked by different jurisdictions. We recognize the doctrine to be an indeterminate, open-ended, and dynamic meta-concept in public law. However, this foundational mapping exercise provides direction to the forcible colonial diffusion of writs in India and Sri Lanka, their subsequent voluntary diffusion in Pakistan and Bangladesh, as well as Nepal and Bhutan, although they haven't been colonized. The chapter shows the PTD to be but one instantiation of adaptation of the writ jurisdiction in most South Asian countries in holding public power to account, especially with regards to protection of the environment. We believe this work can be the foundation upon which future scholarship has the potential to explore the wider socio-political context in which the doctrine gets invoked, engage in theoretical, philosophical appraisal, and provide normative judgment on the use of the doctrine. It has the potential to pave the way for meaningful recommendations for reform or use of the doctrine for courts, constitutions, or other actors that wield public power in the areas of administrative law. And so we hope that this chapter could be but one in a larger project of comparative administrative work in South Asia. I think that's 1 minute over. Thank you, Oren, for bearing with me. And thanks, everyone, for this opportunity.
It was so interesting, so not at all bearing. So thank you, Tavini, for this presentation. Really, I have lots of questions that I'm going to keep for Q&A. But let me go to, hi, Susan, welcome. I think we're going to try and wrap up the kind of chapter presentations, and then we'll give you the stage to comment. Okay, so I'm going to invite Professor Noah Rosenblum, who's an associate professor of law at the NYU School of Law, writes about administrative law, constitutional law, and legal history. And Noah co-authored, again, one of the interesting chapters in the book comparing France and so back to the global north, France and the US and judicial review.
Thank you for having me. I really can't follow Tavani's presentation. I feel like listening to you present your work, it made me understand everything Mariana was saying about why we needed to globalize and change the perspective. And so I feel a little bit rebarbative and reactionary since, as Oren was just saying, this is a return to the bad old comparative administrative law of global north and global north. When Megan was talking about the length of development, it reminded me that this paper actually has its roots in conversations that go all the way back to the pandemic. When Cyril Beaufils, who's sorry he can't be here right now, my co-author, he and I were just talking on the phone in the midst of lockdown. He was working in an academic office inside the Conseil d'État that had comparative law responsibilities. And I was just starting off as a law professor. Back then, I was a new voice, if no longer. And we were talking about part of what we were noticing in the law that we worked on. Some of that had to do with the COVID pandemic itself, as in both countries, the courts responded to administrative action taken as a result of the pandemic and the political fights that brewed during the pandemic spilled over into courts and into debates about administrative law. We noticed that increasingly informal administrative actions and materials were swept up into judicial review. So whereas once judicial review might have focused on formal administrative documents like agency memoranda or rules or enforcement actions, in both France and the United States, it started to pick up a wider variety of documents, including circulars, circulaires, tweets, statements of expected action. And the tenor of the review was changing. It seemed increasingly as if judicial review was functioning as a forum for pursuing what were political disagreements. So some of the very same arguments that parties might make before agencies were now being revamped in front of the courts. And the very fights that the agencies had sought to resolve would now reappear as the crux for the argument of judicial review. To stylize, judicial review wasn't functioning so much as courts making sure that agencies were doing their jobs. That's how I teach administrative law to my students, but rather as another forum, maybe a friendlier forum, to re-adjudicate a fight that you might have lost in front of the agency. So the chapter that we wrote was kind of trying to systematize those observations, to go back to Tavini's nice theory about how to do doctrinal scholarship, maybe do it in a more rigorous way, and see what, if any, conclusions we could draw from those developments. Okay, so having given you that overview, let me just walk you through the argument in a little bit more detail. So the chapter starts by highlighting some of the key differences between the system of judicial review of administrative action in the United States and in France. It may be the bad old world of global north comparative administrative law, but there's still interesting things you can learn from it. In particular, Cyril and I were struck by how many similarities there were between the French and American systems, despite the fact that you could imagine them as being part of a prototypical contrast between a common law jurisdiction and a civil law jurisdiction. In both France and the United States, you have well-developed systems that allow judges to review administrative action, including the powers of the judiciary to set aside administrative action on a nationwide basis. And strikingly to both of us, in both countries, when adjudicators discuss what their goals are of doing this kind of judicial invigilation of government action, they point to the same values. In both countries, there's an idea that judicial review of agency action is supposed to promote efficacious government. It's supposed to ensure that agencies do not act ultra vires, and that in particular, they promote individual rights and liberties. Okay, but of course, there are some critical differences. The judges who do this review play very different roles in each of these systems. So in the United States, judges sit outside the regular policymaking or agency decision-making apparatus. They're supposedly an independent branch of government. Judicial review happens ex post after the conclusion of agency action. In France, this is all very different. The judges who review administrative action are much more part of the government. They can review laws before they go into effect. And while at the moment they are independent of the executive branch, they do retain a disposition that Cyril convincingly persuaded me traces back to their historical origins, in which they were much more part of the government, and they had a responsibility there as helping to keep the government's administrative house in order. The structures through which they act look very different too. The US is highly decentralized. The French system is highly centralized by contrast. Okay, these differences affect the way that the developments Cyril and I noticed during the pandemic were playing out. So consider our observation about political combat. In France, most of Macron's key proposals were indeed challenged in front of courts. Sometimes the Conseil constitutionnel, the constitutional court, often the Conseil d'État, the Supreme Administrative Tribunal, sometimes both. But the very centralization of these challenges meant that in the end, each of these bodies heard the case once, and they heard it in a relatively timely fashion. So Macron's retirement benefit reform, which was highly controversial at the time we were writing, received pre-enactment review at the Conseil constitutionnel, received post-enactment review at the Conseil d'État, failed during the pre-enactment review, but that failure led to a revision of the implementing regs by the Conseil d'État. And there you go. In the United States, by contrast, decentralization has led to a much more scattershot response to administrative regulation. So all of the major initiatives of then President Biden were also challenged in court, just like with Macron. But you had a bunch of different district judges, each of whom was making their own call. And then you had these doctrines, like the major questions doctrine, that empowered initially outlying judges and then eventually the Supreme Court to take pretty aggressive action. But it unfolded over a much longer time period and with much more uncertainty about exactly how the law would develop. By the time the rulings came down, Biden's term was basically over. Okay, centralization had less of an effect on the other major development that we were intrigued by, the review of what in France is called littérature grise, a term that I wish we could import into the United States. Gray literature, these sort of semi-official documents somewhere between a formal notice and comment rule or a statement of agency policy on the one hand and just like, something an administrator might say at a cocktail party on the other. It covers these materials that are neither official pronouncements that affect rights and duties, nor mere working papers, but something in between. Okay, in France, there are legal limits to what ordinary ministers can do with respect to regulations, but they can and have increasingly been using this gray literature, littérature grise, to maybe affect these regulations without exercising their formal powers, which in any case here would be ultra-virus. As a result, the Conseil d'État expanded its provisions to allow for reviews of these materials to ensure that administrative action was not falling through the cracks. There's a great example of this in the chapter with respect to a press release from the French Financial Markets Authority, which did not purport to establish any new rights or rules, but which clearly was affecting markets and so got swept up by the courts for review. Something similar, of course, has been happening in the United States, although it seems more connected to growing political contestation here than maybe in France. Similarly, we have a rule in the United States that limits what courts can review under the Administrative Procedure Act, but there's a worry that some major controversial policies were being implemented through mechanisms that might appear to evade this form of review. The example we worked through in the paper is the Deferred Action for Childhood Arrivals, the DACA plan, which was a centerpiece of President Obama's immigration policy. It ended up relying on documents like, in this case, more formal documents. The documents themselves were formal, but the policies were the kind that you might have some arguments over, at least before the court swept them up, whether they were the kind of final agency action that could be subject to judicial review. So we saw the court just expand without explanation its review to these kinds of policies. Maybe more directly in line with the gray literature example, in the Biden student debt case, technically the plan that President Biden announced for how he was going to forgive American student debt was in a press release at the time it was challenged in court. And yet the court was happy to sweep up this press release into what ultimately was judicial review of administrative action, for which in the past you might have expected an actual formal final agency action and implemented plan, something like that. But in this case, the court did the review on the basis of intentions and memos, not an implemented plan or action. These developments have not gone unremarked by the judges themselves, who have developed different strategies for dealing with change. And this opens the possibility for some cross-cultural learning, which is what I'll end on and what we ended the chapter with. The insight that Cyril and I maybe the one major insight that we had together doing this comparative work is that these developments, this basic development, the increasing staging of political contests in front of agencies, the two particular phenomena connected with it, including this review of gray literature, these developments might not be bad developments. So while I think especially for administrative law scholars, it's pretty reflexive to decry politicization, politicization can be really valuable. So in France, judicial review of administrative action was the only forum for ventilating fights over the COVID-19 restrictions. The parliament for some of that period was just out of session. If we didn't have those fights in front of agencies, we might not have had those fights at all. And given how divisive an issue it was, if you're interested in deliberative forms of legitimacy, maybe it was important to have the fights there. In the United States, judicial review of agency action has been a key tool for people who feel aggrieved by presidential action and have not been able to find redress in other fora to bring those arguments forward. And exactly how you feel about that may depend on how you feel about the presidential action being contested, whether it's Donald Trump's actions or Joseph Biden's actions. But I think it's beyond dispute that it can help rein in certain kinds of lawless action. Similarly, littérature grise is a major part of administration today. If we think that judicial review of agency action is core to legitimizing the administrative state, it would be weird if you could just get around it by relying on this gray literature. So surely countries are going to have to develop tools for dealing with it. The problem, and this really does come out when you look at France and the United States in comparative perspective, is that the rules we rely on are not always clear. And the institutional design of court review of agency action in France and the United States risks exacerbating some of the pathologies that go along with increasing politicization of judicial review. So, to be a little blunt about it, in the United States, it's possible that our doctrines have made politicized judicial review just too easy. The fact that we've relaxed the case and controversies requirement, the initially decline and then disappearance of Chevron, these might make it just a little bit, they may make the barrier too low to bringing a political fight into a court. And this could be a cautionary tale for the French, who were expanding judicial review of administrative action, particularly in the environmental context, interestingly enough. When it comes to review of gray literature, maybe there the lessons go the other way. The United States going all the way
I'm just
back.
pointing out that you're at time. So
great. I'm about to wrap up. Sorry, thanks. The United States, going back to these earlier cases, has a test for reviewing certain kinds of gray literature. Maybe the French could benefit from such a rule. More generally, the comparative perspective pushed us to think about the rules of institutional design, how they connect to various doctrines, and how that, in particular, might weigh on coordination questions and centralization or decentralization. So that's the chapter. I'm sorry for going over, and I'm looking forward to your comments and discussion.
Perfect. Thank you. Okay. Susan, do you want to take a few minutes now before we get to kind of more kind of commentary from Emily and Francesca? You're just note that you're muted, Susan.
Okay, no, I'm not.
Let me just say just briefly, Susan, that you're everyone knows, but I'm going to do the honors of just saying that you are the Henry Arliss Professor Emeritus of Jurisprudence and Professorial Lecturer in Law at Yale Law School and Department of Political Science at Yale University. You've written extensively, including about corruption, but I think it's fair to say that you not only, as I said at the beginning when you weren't here, that the initiator of the project, the Research Handbook, but also one of the most important deans of the field of comparative administrative law.
Well, thank you. So I welcomed this third volume and was delighted to have some of the old editors, Blake and Peter, and then bringing on a whole bunch of new editors to put out this third edition, which I think is terrific. And I don't think Noah should be embarrassed, about talking about France and the U.S. They're still very important cases, and that shows up in this new volume, which does a wonderful job of expanding the range of countries and legal systems that are being looked at. I know particularly the discussion that I came in the middle of, but I had read that chapter about Southeast Asia is great. But to me, a sort of a general thing that came up to me in looking at these things is the interesting way in which legal forms such as the common law, or some legacy like the public trust doctrine, say from the UK, all kinds of legal principles that get applied to administrative law out of a common law background, then sort of bump up against written constitutions and statutes in countries outside of, particularly, of course, of the UK. And there's a lot of interesting questions about where those things bump into each other. And I took away from some of the other chapters that, and this is, I guess, particularly the chapter we were just hearing about, is something that the same word that has a traditional public law, common law background, when it gets transferred into the public law area in a country that has a written constitution and a bunch of written statutes, turns out meaning something different. And it's not just the words on the paper, it's the country in which the actions are going on. So the very interesting paper about Indonesia and the Netherlands and the ombudsman in that context, where when the underlying government is extremely corrupt or dysfunctional in one way or another, suddenly the whole idea of what some kind of an independent ombudsperson would do becomes much more fraught, much more overlapping with political issues. I think we're seeing some of that in the U.S. right now, where things that we had thought were pretty well settled norms are being challenged. But it seems to me that to some extent this whole comparative administrative law effort is a way of bringing to the fore these kinds of tensions between, on the one hand, private law doctrines, which have public law implications, and that show up, and the labels that are put on them mean different things in different places. And I think it's been one of the, seems to me, a really interesting contribution that this third volume is making to the discussion. So I am grateful to see all that, and hope that that more people will pick up on this. I'm looking forward to, I haven't been able to read every chapter in the book, but I'll take some time and see what else I can see. So let me turn the discussion back to Oren to move on to whoever should be next.
Great. Thank you so much, Susan. I want to say, it's what you picked up on your remarks is something that actually comes in your forward. You have this line that's very provocative, that you say comparative administrative law is not really a field, but rather kind of a lens to kind of look at deep questions of public law. And I thought that's kind of thought-provoking to say that. Anyway, moving on. We'll go now to the two distinguished commentators to kind of reflect on the handbook more broadly. And I think we'll start with Professor Emily Bremer. She's a professor at the University of Notre Dame Law School, published and writes widely on administrative law and process, constitutional law, and taught, importantly, kind of in line with the institutional building in comparative administrative law, also taught an important class twice now in the London Notre Dame program in comparative administrative law. So the stage is yours, Emily.
Thank you so much, Oren. And I want to start off by saying, thank you for inviting me to do this. And thank you and congratulations to all of the editors of this new volume, and also to Susan. It's a wonderful, I think, continuation of the legacy that these books have provided. So as Oren said, I dabbled a little bit as a scholar in comparative administrative law, but for the most part, my ability to sort of engage in it has been more as a teacher than as a scholar. Notre Dame is I think the only US law school to have an accredited study abroad program. We have a program in London, and I've taught there 2 semesters in 2022 and 2024, and both times I taught a comparative administrative law course. And actually, I did it according to totally different syllabi. After the first time, which went fine, I reorganized it, and you always have to sort of revisit. And I will say that I think the vast majority of the materials that I assigned in that class in both semesters were contributions drawn from the first and second editions of this work. And I'm so excited to see the third one. And I'll say something that I thought when I was looking through the book, and then I was gratified to see that Susan says it in her foreword. So maybe I'm right, that this really is, in an important sense, a third volume as opposed to a third edition, right? It's a wholly new collection of work, and really a continuation and an addition to the material that's in the first 2 volumes. And so if you haven't worked with this book before, I want to say that because I just want to alert you to the fact that it's not a sort of repetition of materials that have been previously published, but rather a sort of expansion of a large and I think influential body of work. And I want to kind of highlight a couple of things. We've heard, there's 4 parts to the book. We've heard a presentation of a chapter from part 1. We've heard a presentation of a chapter from part 2. And so I wanted to focus my remarks on parts 3, mainly part 3, and a little bit on part 4, because some of the materials that are here are just really spectacular, and I look forward to, I've read some, but not all, but I can guarantee you that I will be reading more. In fact, Oren was a little late to invite me to this. I could have gotten a complimentary copy, but the editors will be pleased to hear that I had already bought it. So so someone has. It's always nice as an author when you're like, oh, yay. So I want to focus, first of all, on part 3. The materials that are in part 3 really cover a rich array of subjects on what I would describe, perhaps idiosyncratically, as the kind of on-the-ground realities of administration. One of the hard things about administrative law, sort of generally, and comparative law, I think in particular, is that it's easier to work with abstractions and generalities than it is to really work with the details on the ground, especially in administrative agencies, as things work from the perspective of those who are working for the agencies and those who are appearing before the agencies. There's a real, I think, challenge because grappling with and even wrapping your mind around kind of the on-the-ground realities requires you to go really deep and really narrow, just because the sheer level of detail is such that there are only so many hours in the day. And so it can be hard in an American context to get administrative lawyers to look sort of beyond the sort of the kind of big picture judicial review subjects to really grapple with what's happening in the agencies, in the implementation of the statutes in the first place. And when you sort of add to that a comparative element where you need to get into that kind of depth, not just in one country, but across countries, I think it gets to be extraordinarily difficult. And part 3 does just such a phenomenal job, I think, of providing a really interesting array of subjects that do, and authors who are doing exactly that, right? So you have chapters here on agency outsourcing of service delivery, which of course is something that I think pretty much every system these days does, right? The reorganization of review of administrative adjudication, right? And that's the reorganization is an important part because we're kind of dealing, if I may sort of tweak a term we might be familiar with, we're dealing with sort of late stage administration, right? And these structures in a lot of places have existed for a century, and have been really significantly reorganized in recent times. And reorganizing something presents a very different sort of set of challenges. So introducing that element into it, I think, is really interesting too. Right, there's a chapter on process-oriented review of decisions under conditions of scientific uncertainty. In a certain sense, an old chestnut, but a new approach and a new perspective on it that I think is really great. A chapter on audit institutions. gorgeous, right? This is the kind of thing that is profoundly important in administration and that I think is really easily overlooked, right? A chapter on ombuds, a chapter on the use of comparative law, the Conseil d'Etat. Like I just think the number of subjects here and the kind of variety and richness is just something that is really useful both for scholars but also potentially for teachers. And by the way, if anybody here, you know, on the webinar is thinking about teaching a comparative administrative law class, if you ever want to talk about the challenges of that, and I'm always happy to share materials. I don't know if they'll be useful to you, but I'm always happy to do that. And then I want to highlight one thing from part 4. Part 4 revisits something that I have really enjoyed about previous editions of this book, which is the addition of a focus on international and supranational administration, which just is a totally sort of different perspective on these subjects, and one that I think really invites us to think about things from a different kind of perspective. And part 4 is a continuation of that, right? Administrative governance beyond the state revisited. And there's a variety of chapters in here that I think, again, add to and enrich the body of work that's provided in previous editions of this book. But 2 of the chapters really struck me because they're both about, there's one on conditional spending as an instrument of government, right? And one on funding as a tool in administrative law. And those are such important subjects these days. I mean, in the US, there have been some recent studies suggesting what maybe is starting to become more apparent to all of us, which is that Congress tends to use its spending power more than its lawmaking power to control administration and to change policies, right? And likewise, presidents, especially in this current administration, have been using impoundment and control over spending and budgets as a way to get out of the political process things that they're not able to get, frankly, through legislation and kind of more direct and traditional tools of administrative governance. To see chapters that are drawing on these same things, these same sort of developments, but in an international, a supranational context, I just think is really such a wonderful contribution to the field. So I'm going to stop there because I'm eager to hear the remainder of the remarks and leave time for Q&A. But again, I just want to reiterate how excited I am about this volume, and thank you and congratulations to all of those who have participated.
Great. Thank you so much, Emily. And finally, to our final commentator, Professor Francesca Bignami, who's a professor at George Washington Law School. And I should note that Francesca's textbook for a general course in comparative law was just released, I think, previous month with Foundation Press. And it has a chapter devoted to comparative administrative law. So doubly exciting to have you. And Francesca, the stage is yours.
Okay, well, I'm going to thank you very much for the invitation to read and to comment. And I'm going to first reiterate what has been said by many others in this webinar, which is congratulations to the editors and the authors on really a splendid volume. I found the chapters to be extraordinarily enriching, chapters which really advance the mission of bringing in new voices and new perspectives. So what I'm going to do briefly is to discuss a couple of the chapters that stood out for me and then make one constructive suggestion or comment for the next edition, although I'm not sure whether you're already thinking that far. But yeah. So first off, there were a couple of chapters that I found particularly illuminating just because in some cases I knew very little about the jurisdictions covered. In other cases, because I know quite a lot about the jurisdiction, which is the EU. And so when David Zering and I did our Elgar edited volume on the comparative law of regulation, which focused on the market regulation piece of what administration does, and as opposed to service delivery or Social Security, we tried to include a variety of non-Western jurisdictions. And one thing that was striking to me, based on both the existing literature as well as the contributions to the volume, was that the idea of what law is supposed to be doing when it intervenes in government administration differed systematically across the jurisdictions. And I saw that these different paradigms as being ruled by law in East Asian jurisdictions, preserving classic fundamental rights in European jurisdictions, continental jurisdictions for the most part, preserving the democratic process in the United States, a huge focus on proceduralism compared to other places. And what's most important here for the discussion of the chapters that I really caught my attention was transforming the state in new democracies. In the two global South jurisdictions that were covered in our volume, India and Colombia, the law was being used not to supplement administration or supplement traditional accountability mechanisms. It was designed to replace administration and replace the old autocratic elitist way of doing politics. So law was being used as a vehicle for transforming administration politics. And in our book, in our volume, the Lamprey et al. Chapter on the right to health in Colombia, which is something that in American administrative law would be the humdrum world of Medicare and Medicaid regulation. It was really something that was driven by constitutional law. So access to drugs was driven by a constitutional right to health, protected through the incredibly rapid tutela jurisdiction of the Constitutional Court. And the law was being used to radically transform the healthcare sector of the administrative state. And then in the second chapter that had a global South jurisdiction, which was the Ben Worthy chapter on comparing FOIA in the UK and India, which emerges more or less at the same time in an old and a new democracy, it was striking how the Indian FOIA was highly politicized, used as a vehicle for mobilizing outside of the corrupt and elite world of bureaucracy. So in the UK, the new FOIA was being used to improve routine oversight by the public, but in India, it held the promise really of revolutionizing administration. So in your volume, in this volume, in a number of chapters that cover jurisdictions in the global South, I saw the idea of transformation come out really quite clearly. It seemed to me that the case of the public trust doctrine, which we just heard about in South Asia, has real parallels to the right to health care in Colombia. There's the prerogative writ, which is the court's device for ordering government to do something, first off. And this is similar to the tutela in Colombia, which is this constitutional law device, but still it's a technique for ordering the government to do something. Then in the South Asian case, the public trust doctrine is invoked as kind of a reassuringly traditional common law notion. But really what's driving the case law in India and other jurisdictions that you look at is not this emblematic common law trust where you separate ownership, between legal and equitable, and then the property and the trust is supposed to be used, for purposes of the equitable owners. It's not really that. It's the constitutional law that's driving this. And so, it's very similar to healthcare, I found at least, and the count of healthcare in Colombia and the right to drugs. So this similar aspiration of transformation can be seen in the chapter on FOIA in Caribbean states, which isn't represented here on the panel. But that chapter focuses on how Caribbean courts can use constitutional rights to participatory democracy to make FOIA laws more robust and to limit all the exceptions, right, that exist to FOIA. And so the story in the Caribbean jurisdictions in the chapter is different from one in India, where sort of the entrepreneurial transformative campaigning is done by judges, not by civil society actors. But it still seems to me that FOIA in combination with a constitutional right to democracy makes for a much more radical potential than FOIA as kind of a humdrum managerial way of dealing with government documents and supervising agencies in the UK, in the United States, and other old democracies. So those are some of the chapters that I found illuminating from the perspective more of an outsider, a tourist, somebody who's made some observations about jurisdictions in the global South. And it seemed to me that they really, in a very direct way, confirm some of those observations. Now, from the perspective of an insider, I really want to commend the chapters on European fiscal governance and conditionality. Those are terrific chapters. And I've followed those aspects of EU law quite carefully, but it's an extraordinarily technical branch of EU law. And since COVID, there have been so many changes, making it much more complex by adding new sources of funding and new types of conditionality. In the last 3 chapters, they do a remarkable job of unpacking all of that. So that's going to be my go-to now for trying to figure out how the Europeans use spending and conditionality, because they do the technical work of it, but then they also unpack all the big normative and legal debates. So I highly recommend those. So this brings me to my second big point, which is just a constructive comment for the next edition, for the 4th edition, or just the next volume, if you're not going to call them editions. And that is to include more civilians. Because it's no surprise that the EU chapters are written by civil law jurists. And in Romano-Germanic jurisdictions, the focus of public lawyers is as much on the organization and powers of administration as it is on the law that checks administration. And fiscal governance is all about organization and powers, And so it's very, it's not surprising that you have Italian, German, I think Spanish jurists writing about that. I don't want to make assumptions there, but they're Romano-Germanic jurists. And in the next edition, I think it would be interesting to include more of that civil law perspective in the earlier domestic focused parts of the book, which I don't think they're entirely biased towards common law, but they tend to reflect a lot of common law and a lot of common law jurisdictions also in the global South. And at least in the American tradition, we don't really focus on the mechanics of administration, as observed in the Sanchez et al. Chapter on conditionality. But maybe we should, So part of what's so disorienting about what's happening in American administrative law right now is that all the big challenges have to do with the organization and powers of administration. So, all these norms that seem to be settled, civil service employment, the executive's use of government contracts and grants to achieve political purposes, the executive's discretion with respect to grants and aid to the states. These are all things that somehow, that strangely fall outside of the core aspects of, the American canon on administrative law. They aren't part of the textbooks. You don't have a section in a textbook on civil service, on, government contracts, on grants, etc. But you do in civilian jurisdictions. That's the first part of the textbook. And so I think that the civilian experience, which can help with building that American canon, so developing an American administrative law of the state, right? Of the state, and not just checks on the state. So I'm going to conclude there, but I want to repeat myself in saying thank you for this excellent volume. I'm going to keep on reading, and I look forward to our conversation.
Perfect. Thank you. Thought-provoking. So here's what we're going to do. We're going to start collecting questions. So all the participants and the panelists, if you haven't noticed, there's a Q&A function. It always surprises me that this is what webinars have rather than chats. So you can open the Q&A and you can actually see there's already a question there that I will read. I just wanted to ask Mariana, Megan, Blake, if you want to start off, or do you want me to ask a question, or you want to respond? Okay, so Mariana wants to respond, and then I'll wait with my questions. Go ahead, Mariana.
Just 3 very quick comments. I think Susan already replied to Noah, but I just want to, for the record, this is not the bad old world of comparative law. It's the wonderful old world of comparative law that's now being reached by many other jurisdictions as part of the conversation. So it's a yes and bring more of what we're doing and a little bit more. So I think that's point number 1. Point number 2, Emily, I think your point about this being an entirely different volume is very well taken. We did have some discussions around third edition and third volume. I think some of the authors also seconded that. But at the end of the day, the publisher had their preferences, and that was that. But very well taken point. And I just want to thank Francesca for this suggestion, right? I think the civilian discussion is an entirely different one that I think can also help enrich how we look at different jurisdictions, especially common law jurisdictions. One of the challenges we do have, though, is, and I speak as someone who comes from Brazil and therefore a civil law jurisdiction, one of the challenges is the specialization exactly that you mentioned, right? Like, because administrative law covers so much of the functioning of the state, you end up having these very niche discussions for each of the areas that end up being very specialized. So would be a very, I'm just saying that to say it would be a very interesting challenge, and I think one worth engaging with, to think how we can include more civilian voices in another future volume. Thank you.
Great. Megan, Blake, anything to add, or should we go to some questions?
I think let's do some questions, and happy to chime in later if useful.
Okay, sounds good. So, Tavini, I'll read next the question. I don't know if you see there's a question directly about your presentation, but let me ask another kind of general question or two. One thing that I was thinking, something that Blake said, and really also comes pretty strongly from the volume, is the message of plurality and differences across jurisdictions. And I think it's a very much a deliberate decision by the editors. I wonder how much it reflects. I don't know if you have thoughts. It reflects that the field itself has really moved into kind of buying into the plurality framework rather than a kind of a picture of a global converging administrative law. I wonder, I think it seems to me like that kind of conversation still happens outside perhaps the volume, but the handbook is trying to push a different vision. So I wonder if you have any thoughts about that. Another question that I wanted to ask is about maybe Tavini's chapter. And I was so interested in the chapter and the idea of public trust. Again, Noah portrayed the global north as, the bad wolf. And I'm also a sinner of doing the bad wolf, just because of the limits of my own knowledge. Although, of course, what's out there is expanding our knowledge. There's such hunger today, especially in the global north or even the US, where I'm embedded, in these kind of vocabulary of public trust to kind of make administration more kind of inflected, public interest inflected. But, there's another sort of concern, and it actually echoes some of the things that Francesca said. What are the risks in the public trust framework that is borrowed from a kind of a common law, private law framework that tries to constrain private actors, at least originally, when we take that idea to the kind of state context? So the question is, what I'm curious to know is whether the public trust doctrine, PTD, had any in the global south and in the five South Asian jurisdictions that you've been covering in you covered in your co-authored chapter. What are the responses, or what might be the risks of not, going after this public trust doctrine, whether it comes from a common law or the Constitution, rather than a more, what I think sometimes is a more public law framework for administrative law that talks about, notice and comment, participation, discretion. Like, this is a different sort of array of tools to apply to try and control and structure public power. So I'm wondering if that sort of debate also plays out in the jurisdictions that you focused on for your chapter. Okay, so just out there, if you want to respond or take another question, that's also fine.
Should I go? Okay. So if I could just respond to the specific question that Oren asked, and then going to Seming's question in the comments. So what you ask in terms of perhaps the risks of public law utilizing this public trust doctrine, which was originally seen with regards to more private actors in terms of how it was viewed under the Roman law or English common law. This is something that we spoke about. And looking at how, to what extent the public trust doctrine has developed within South Asia specifically, what we noticed is that, well, apart from Sri Lanka, all four other countries have used it to further environmental constitutionalism. And this kind of top-down approach towards protecting the environment has precluded conversations about how risky it could be in utilizing this doctrine in order to pursue that objective. Whereas in Sri Lanka, where it has been used in a much more broad sense, developed by Sri Lanka itself in terms of recognizing public power as something that's held in trust for the people, as opposed to something like environmental resources that are held in trust for the people. Again, there haven't been conversations by courts or any other actors about this, but while we were writing the chapter, there were a lot of concerns that came up with regards to just how indeterminate and arbitrary this doctrine seems. At the moment, looking at some of the decisions that have come out, you can see that this is just simply the judiciary as like the last line of defense, stepping up to curb some of this is Dinesh's word, but like constitutional shamelessness of some of the other actors. And while looking at a certain case by case use of the doctrine, it might be able to be defended because of some of the unacceptable actions of other constitutional actors. The malleability of the concept and the fact that the contours of the concept are just not clear, I think does make the doctrine extremely risky because of like its indeterminate nature. And unless it's going to be clarified in the future, to just invoke it arbitrarily by the judiciary as they go on, definitely is not a very sustainable use of the doctrine, or it's definitely not going to bode well for the doctrine in future, especially in Sri Lanka. And to Seming's question, where I'm sorry, just looking at that real fast, but please correct me if I'm wrong. I think the question is, looking at the 5 South Asian jurisdictions that have utilized the public trust doctrine, what leads us to say it's rooted in some of the sources like common law, constitutional provisions, or statute. So again, this is a great question. And because there was so little work done on the public trust doctrine, although it has been widely used in South Asia, we really went into kind of exploring exactly what courts are looking at when they kind of invoke these words. And I think one of the questions you're asking is, was it functional equivalence that led us to make the connections between the jurisdictions? And so I think it was, to an extent, functional equivalence in terms of the result that all the countries were getting to by using the doctrine. Also, like as a starting point, because this hadn't been done before, we were looking at like the terminology, the vernacular that was being used, as well as how it was being used in all of the sources that they were drawing from in using this doctrine in all of these jurisdictions, where we saw the principal diffusers to mainly be, interestingly, the work by a scholar in America, Joseph Sachs, who is kind of credited with revitalizing the PTD in the US through looking at several case law. So what we saw in all of these jurisdictions is that they seem to refer to the, like, especially the Illinois Railway case from the US, as well as kind of this international environmental law jurisprudence that has come out. And that's how we kind of traced like in what all these countries were considering the PTD to be and how it was being used. And that is what kind of facilitated the comparison in identifying, and yet even within that doctrine, the similarities and the differences. I'm not sure if I answered the question properly, but yeah.
Sounds great. Yeah. I should, by the way, note that some of the authors of the other chapters are in the audience, including the ones that people flagged here. So just so you know, they're here. Okay, so Blake and then Megan, and then we'll see if there are other. If you have questions, you can type attendees in the Q&A.
Great. Yeah. So just to follow up on some of the themes that have been raised about the global South and the global North, I think one of the interesting features of this important line of scholarship is it can also change the way we think about the global North as well. For instance, I was recently reading uh, Emily Bremer's colleagues, Christian Bursett's book on the empire of laws and the exporting of common law principles across the empire and when that was chosen and when it wasn't as a matter of policy. Um, and if you think about that broader history, it might also help us to rethink, for instance, the United States, where the prerogative writs traveled here, and Marbury versus Madison is a mandamus case, involving whether or not you could compel the delivery of a commission for office. And so this legacy does provide a kind of unifying frame for comparison that also I think is normatively challenging. That the frame is provided by an exercise of brute power as well as of law. And I was also struck that King Charles appeared before Congress yesterday and invoked Magna Carta as a check on executive power. So it's remarkable the staying power of these legacies, and I think it's a really important project for the future to continue for us all to wrestle with them.
Megan, yeah.
Thanks so much. So, I have a question, I guess, for maybe Blake or Noah, as our resident experts or people with experience, quite a bit of experience on the sort of history of administrative law thought in America. And the question sort of comes from some of Francesca's comments. So, she's given us the very helpful suggestion to reach to civilian jurisdictions, because those scholars working from those traditions might be able to give us a bit more perspective on administrative law as a model of government and focusing on empowerment rather than just constraint. And that comment struck me as interesting because I have a sense that at least the common law traditions that I'm most familiar with, there is a sort of tradition, albeit a slightly quieter one, of thinking of administrative law through a model of government and focusing on matters of empowerment and how to structure administrative agencies, and then thinking about legal constraints through that model. And I just wondered whether you think that there is a parallel, if under-tapped set of resources from the American context that we could have brought in to talk about empowerment.
Noah, Blake, yeah.
I'm happy to just jump in and say that I think my sense is that the American administrative legal tradition has also always been concerned about empowerment. And I don't mean that in a sort of conflictual posture. I think because of the way the doctrine has evolved, we tend to focus more on the constraint question. But whether you think of it from a political theory angle or from a institutional design angle, the twin responsibilities were always accountability and efficaciousness. And so, if you think about something like James Landis in the administrative process, he's concerned not just about, maybe not even primarily with the constraint aspect, but with the way that administrative law is a story about empowerment. I think the kind of the challenge or question is that in the United States, since, I don't know, the 1950s, maybe, I'm not sure when we would start it, there's been a pretty big division between the fields of public administration on the one hand and administrative law on the other. And public administration as a field has undergone its own revolution, where in the first half of the 20th century, it might have been more explicitly focused on questions of empowerment. But in the kind of neoliberal age, it became very concerned about questions of management that were implemented on the micro scale. But the result of that radiation, the sort of the separating out, is that I think some of the unity of the field, which it sounds like is maybe still more visible in other countries was lost in the United States. That might be my kind of initial take. Although, for whatever it's worth, in conversations that are happening now about, what should administrative law look like in response to some of these transformations, I think you have a lot of law professors who have been trained in more of a constraint tradition saying, hold on, we have to talk about empowerment, efficaciousness, state capacity, just as centrally as we talk about constraint.
Can I just add something to
Please.
what Noah was saying? There's a whole field in political science and economics that has to do with the evaluation of public policies, and that's much more in the US and in the UK, not particularly related to the common law tradition, but thinking of government as accomplishing things, and its relationship to intellectual traditions that might help do that. And that's actually stronger in the US than it was in the past, at least in parts of Europe. And so it's not as if there hasn't been a lot of thinking about how policy ought to be made, or how bureaucracy should be structured. It just isn't generally what's been in the course on administrative law. And so I think it's that a lot of the overlaps that Francisca, I think, was very rightly pointing to, or the issues that she was pointing to, have sort of popped up in other places, and they're somehow are. That would be an interesting question. Why have they not been? Why isn't there anything much on government contracts, or even on state and local government in the traditional way administrative law is taught? There's not that the issues are recognized somewhere, right? So anyway, thanks.
Blake, we're at time, but go ahead.
I would just say briefly to follow up on Susan and Noah's remarks that I think part of the legal issue and not the political science issue is that the way that the question of empowerment tends to be framed in the US and in other jurisdictions is simply in terms of discretion. That empowerment means that the executive and the legislature have the freedom to choose. And the problem is that when you frame empowerment as discretion, which faces on the other side a right, the right sounds like it has normative priority. And I think that is a deep flaw in the way public law has developed in the United States. I don't think it's necessarily consistent with a lot of the tools that we have at our disposal historically, such as concepts of public right. But this is where we've landed. And I do think it's an important project to think more deeply about affirmative rights and obligations.
Yeah. Okay, so we're at time. We're even a bit after time. So just one final word of thanks to the participants, and congratulations to the co-editor. Congratulations also to Susan for seeing this project coming to this another achievement, and to everyone who attended. And hopefully we'll see you soon in person rather than in Zoom.
And thank you, Oren, for pulling us together.
Thank you, Oren.
Yes, thank you very much, Oren, for all your help.
Bye. Thanks, everyone.
Bye, everyone.
Great. Bye-bye.